You're listening to Beyond Borders, the Immigration Evaluation Podcast, the go-to podcast for mental health professionals who want to be expert immigration evaluators. I'm your host, Dr. Mariella Shibley, and I'm here to help you turn your expertise into impact. Let's get started. Today we have a truly remarkable guest joining us. I am thrilled to introduce Ginger Jacobs, an accomplished immigration attorney with a thriving practice in San Diego, California. Ms. Jacobs is a Harvard Law School graduate and an experienced litigator who has dedicated her career to advocating for immigrants' rights. She has represented clients in immigration court for all types of relief, from asylum and withholding of removal to adjustment of status and cancellation of removal. Her track record of success speaks volumes, with dozens of clients finding new hope and stability through her tireless efforts. Ms. Jacobs is a long-standing member of the American Immigration Lawyers Association and a former member of the executive committee of her local chapter. Back in 2007, she received the prestigious President's Commendation from AILA for outstanding achievement in coalition building in her community, which is a testament to her leadership and impact. Now, beyond the courtroom, Ginger has played a pivotal role in shaping immigration reform policies, including working with the San Diego Regional Chamber of Commerce, and she's also dedicated 10 years to the American Bar Association's Immigration Justice Project, serving as both a board member and chairwoman of the advisory board. Today, she continues her community service on the board of directors of the Christ Ministry Center in San Diego, and her pro bono work equally inspiring. She is counsel to Alliance San Diego, offering her expertise on immigration policy and supervising workshops for naturalization applicants and DACA recipients. She also serves as an advisor to the University of San Diego's Appellate Law Clinic. And on top of all that, Ms. Jacobs is fluent in Spanish, and she actively engages with the community through presentations and workshops in both English and Spanish. She's been a leader in the San Diego Dreamer Assistance Network, directly helping hundreds of young immigrants with their DACA applications and renewals. So we are so fortunate to have her here with us today to share her insights and experiences. If you're a mental health professional looking to collaborate with attorneys, or an attorney wondering how to best utilize these evaluations, this episode is for you, because today's conversation will provide valuable insights from a legal expert perspective. So here we go. Welcome, Ginger. I'm so happy that you agreed to do this with me. I know we go way back, right? It's been how many years since we've been working together?
I know it's been at least since 2013, maybe earlier than that. At least, I would say 12 to 15 years.
Yeah, I agree. And I keep learning so much from you and your feedback, which is wonderful.
Oh, thank you so much. Same.
So why don't we just jump right into it, yeah?
Absolutely.
So to start, I want to talk about sort of the big picture. Psychological evaluations are often a key part of immigration cases, but not everyone understands why they're needed. So why do attorneys need psychological evaluations, and what types of immigration cases benefit most from them?
That's a great question. Part of the reason that immigration attorneys need psychological evaluations is that we need to have proof of everything that we're saying. So it's one thing for me to come in and say, I, the lawyer, perceive that my client is depressed, or for my client to even write in her declaration, I feel depressed. And it's entirely different to have an independent psychological evaluation where diagnostic tests are administered and a psychological professional actually comes forward and says, here is the diagnosis, depression. That's much better proof than just either myself or the client saying that. Why would we need to prove a client's mental health status? And it varies based on the case type, but let's start with hardship cases. So we have to prove extreme hardship in certain cases and exceptional and extremely unusual hardship in other cases. Oftentimes, mental health is involved as a hardship factor. So why would the, let's say, US-based family experience this extreme hardship if their loved one had to leave? The reason we need an evaluation is because we have to show that the US-based family would experience hardship over and above what is usually expected from family separation. So, family separation is not enough to prove that a client would experience emotional or psychological hardship. We have to show that they would suffer it at an unusual or an extreme amount. How do you prove that? The only way you can prove it is by having an independent professional like yourself and your team come in and actually administer the diagnostic tests, not just have a little chat and then write up a note saying, yes, Ginger's depressed. That wouldn't cut it. The best psychological evaluations are the ones in which different diagnostic tests are administered, and the psychologist comes up with an independently derived diagnosis.
Right. Which is not just a regurgitation of the client's hardships,
Exactly.
their concerns about their finances, et cetera, right?
And it's fine to explore what they're worried about with them. But at the end of the day, everybody's going to be worried about finances, not seeing their loved one, not having two parents in the home. Those are not considered unusual hardship. So if we're looking to prove an unusual hardship, we may need an actual diagnosis of a serious mental health condition. And that would help prove to either the judge or the adjudicator that indeed this person would suffer hardship that's above what a normal family would suffer in a separation situation.
What would you say, what would you do for provisional waivers, for example, where the couple is still here and there's a lot of denial going on, right? People don't want to think of the worst case scenario. And honestly, the idea of it sounds horrible, but not to a degree where they currently meet criteria for a diagnosis. So how can a psychological evaluation still be helpful and useful in those cases where there isn't a diagnosis?
That's a great question. What I do with my clients when they're in denial, and when we're just talking about the case generally, and I'm trying to help them identify what their different hardship factors are, is I say, I know it's hard to imagine right now because you're together, you live together, everything's great. But when you imagine, let's actually talk about it. If Ginger or if Mariella is not able to stay in the country, what would you do? And people might be like, oh, I don't even know. It's like, no, we really need to think about this. Would you stay in the US and then live your lives separately across the border? Or would you move to that country to be with her and then have them really psychologically put themselves in the position or mentally put themselves in the position of where they would be if they had to move, if they had to relocate, or if they had to be separated from their loved one? Now, some cases just aren't necessarily going to be unusual. Let's say if it's a couple where somebody's living in Tijuana and the other person lives in San Diego, but not all of our clients are from Mexico. We have clients from countries all over the world where it might be incredibly difficult
Right.
and expensive to go visit a loved one, and they may only be able to see each other twice a year. And they need to actually internalize that thought and really think about it and think about how that would impact their lives and their well being. You can get people to actually focus on, hey, these are the real life consequences. And I think right now, under the Trump administration, it might actually be easier to get people to focus on the consequences
Yes.
than it was, under different administrations.
Mm-hmm.
Like, hey, what if Trump comes and deports you tomorrow? What do you feel? And then the person might actually be able to express, well, gosh,
Mm-hmm.
if my husband left and moved to a totally different country, I would feel really anxious without him because he's the one who helps calm me down when I'm experiencing anxiety.
Right.
Allow the evaluator to get into some deeper issues that maybe the person was glossing over that perhaps could lead to a diagnosis. Or I'm not really sure because I'm not a psychologist.
Right. Right. Yeah.
To be honest. But I don't know if you're asking, like, would a psych evaluation where the person is completely mentally healthy and has no diagnosis whatsoever, would that still help me? I'm not sure that it would.
So, the way that we tend to approach these situations is, we kind of look for the vulnerabilities, right?
Mhm.
So, things that would predispose them to suffering in the case of a separation. So, sure, they may not meet criteria for a diagnosis right now, but they have a history of abandonment. They have poor coping skills. They have, an insecure attachment with, their spouse.
Right.
And so, all those things are kind of a recipe for disaster if a separation were to happen. And so we kind of emphasize those aspects and, and not so much the actual diagnosis
Right.
that they may not meet criteria for.
I was going to say, in a situation like that, would it be more helpful to do a family diagnosis, like to have almost a family therapy session and to look at the way that the couple or the family members interact with each other and see if that would provide more information to add to the report?
There are some evaluators who will want to see both the qualifying relative and the applicant. And like in waiver cases or in cancellation or removal, they might want to see, again, both the respondent and their qualifying relative. And I actually don't do that. And I have my reasons for not doing that. But what do you think of that, of bringing in the partners or the family members? How objective do you think that would be?
I have used that before, very rarely, but a parent-child case is an example of where I thought it was appropriate
Yes,
because the psychological professional could observe
of course.
the parent-child dynamic.
Yes.
So I haven't necessarily used it with two partners,
Mm-hmm.
but I can see, I mean, we have had some cases where the qualifying relative, let's say the US citizen spouse, has had such deep psychological damage from something, incredibly life disruptive, like molestation or rape, where the non citizen partner almost acts as their in home counselor.
Mm-hmm.
And I think it might be interesting to develop not just the US citizens' hardships and their predisposition to abandonment issues or anxiety, but also to take a look. And maybe it would be better if it was a different psychologist. I'm not sure if you feel like there would be an ethical issue.
Oh, to see them both?
Yeah, to see them both,
Mm-hmm.
like to see the person who's really providing that in-house support and to maybe be able to independently say, yeah, this person seems really, they are really stable. They're really supportive. Like
Mm-hmm.
they're a very, caring person. They express a lot of affection and concern for their partner.
Now, how much weight do you think that would have for the adjudicator?
I think it would have more weight than just somebody saying, like, I would be lost without my partner.
Mm-hmm. So somebody commenting on the quality of their relationship
Mhm.
could actually be helpful.
I think so. Again, we haven't used it very often,
Mm-hmm.
but I do remember a specific case where the psychological professional sort of really evaluated the relationship
Mm-hmm.
between the two people. And that was
Mm-hmm.
a case that we won. But the US citizen spouse had been suicidal, I mean, had some really serious mental health issues. And the evaluator was able to say the non US citizen spouse is incredibly supportive. I mean, she was able to comment on the dynamic
Mm-hmm.
and how important it was for the US citizen spouse to continue to be with her spouse and how necessary that was.
Mm-hmm.
So I felt it was very helpful to the judge. And that was a cancellation of removal case. So that's exceptional, extremely unusual hardship state.
Right.
So I do think that that evidence was compelling and that the mental health professional did come in and testify in court.
Oh, okay.
But it was very helpful that she had met and observed
Mm-hmm.
both members of the couple.
Yeah, and another thing that you were commenting about the current administration, it's interesting that you say that. So a few months ago, like middle of last year, we evaluated somebody. I believe it was for a provisional waiver, and he presented to us as a person with a tendency to worry, but he didn't really meet criteria for any diagnosis, right?
Mm.
And then we get a call early this year, towards the end of January, and he said, "Hey, my attorney wants me to see you again because I have not been the same since this new president took over.
Mm.
I'm constantly worried about my wife getting deported, about what's going to happen. I'm not sleeping. I'm losing concentration. I'm getting in trouble at work." And he came back in and it was like a completely different person.
Right.
And this was totally genuine, right?
Mhm.
This wasn't, it's like all of a sudden, like it dawned on him that this could really happen. And of course, now he did meet criteria for a diagnosis. But so it's interesting how sort of the reality can really bring it home, right?
Hmm.
And then that gives way for all these symptoms to emerge.
Right. And we are seeing in our office people who are clearly exhibiting anxiety, really
Hmm.
expressing fear in a more intense way than what we observed under, for example, the Biden administration, the later years of the Obama administration. I'm sure it's genuine because in my office, they're not being psychologically evaluated at all. But I can see the signs are visible to me
Right.
that these people are suffering. So, where we're going to move into another category of evaluations, which is evaluating how a particular experience has impacted somebody's life. So, that would come in with an asylum case, a U visa case, or a T visa case. So, what the immigration attorney is looking for is corroboration that the person is suffering on account of a certain event, that they're not malingering, they're not kind of making up symptoms, that it's not the story itself is not made up, the underlying thing that they're expressing that they were traumatized by. Because I'm sure that a psychological professional is more adept at perceiving that somebody's making up a story than
Right.
just a general member of the population,
Right.
that we'd be looking for corroboration of a tragic or severely traumatizing event. And in many of these cases, for example, in the U case and in the T case, we're trying to establish that the person continues to suffer on account of having experienced the traumatic event.
Right. And the suffering doesn't necessarily need to be a symptom or that warrants a diagnosis. It could also be just a change in their worldview, right?
Mhm.
Issues with trust, with feeling safe, with like irrational fears, like all those things that perhaps are not put together. They don't comprise an actual DSM diagnosis, but that are changes in their personality and their worldview
Mhm.
that happened as a result of that trauma, which sometimes happened a long time ago, which is why we're not seeing all these like vivid symptoms.
And again, the reason why we need an evaluation is because in immigration cases, everything needs to be corroborated. Every element needs to be proved. It's not really enough for somebody to say, I'm experiencing a lot of psychological symptoms because I went through this trauma. Under the Real ID Act, which came into effect in 2007, this is specifically applying to asylum cases. But I do see adjudicators kind of adapting this train of thought, is that everything that you're saying you have to prove. And if you're not able to prove it, you have to explain why you're not able to prove it.
Interesting.
So it really ups the responsibility or the obligation of the immigrant to prove that what they're saying is true. And so a psychological evaluator can be very helpful in these types of situations.
Right. And would you say that's going to be even more so with this new administration?
Absolutely. This administration has already gone after asylum.
Hmm.
They cut off the ability of people to apply for asylum at the border, for example.
Yeah.
We've been extremely limiting in the refugee program. So the administration does not appear to have much sympathy for people who have asylum or asylum like claims. It goes against the spirit of being a welcoming country and saying everything about what this country is supposed to believe in, right? And even international treaties requiring us to do certain things. But back to the corroboration issue is yes, absolutely. We're going to start to see more requests for evidence, more notices of intent to deny. And those types of documents are basically the government saying, we are inclined to deny your case, prove otherwise.
Yeah. So, along those lines, side question. Lately, I've been very mindful of when they share something like, for instance, oh, my daughter's grades are dropping in school because she's so stressed out about her father's potential removal or whatever,
Mhm.
right? Or my doctor says that my problems are due to stress. If we write that in the report, as you were saying now, like, would you want them to validate it with the evidence? Could that trigger an RFE with the adjudicator saying like, well, show me your daughter's grades
Yes,
to see how much they're dropping, or, well, I want a letter from your doctor saying that this is due to stress.
absolutely. I mean, we do ask people to go to the doctor and get an evaluation, a diagnosis if they're experiencing big stress related physical health symptoms.
So lately, my question has been, do you have evidence of this that you're going to submit with your application?
Right.
And if they say yes, or I have an upcoming appointment, whatever, then okay, I go ahead and include it. But if not, I'm very cautious for that reason.
Right. Well, I would think that if they can't prove what they're saying,
Hmm.
then it may not be true.
Exactly. And it would dilute the weight of the report, at best. At worst, it might trigger an RFE.
Right. I agree with that.
With like, you didn't say anything about your daughter's grade. I don't see any doctor's notes here,
Yeah.
any medical records. So go ahead and show me the medical records.
Right. I think that's absolutely fair.
Hmm.
One of the other things that you and I have talked about before is the risk that including too many details about a person's account could end up being something that could be used against that patient on cross examination if their memory of the event, let's say, is slightly different when they talk to you and slightly different when they testify, which, as we know, could be very explainable if the person is traumatized or has PTSD. But we had a situation where we had a client who was on the stand, and
This is an asylum case?
yes, it was an asylum case, said something to the effect of, I was in the desert for 4 days. And the government attorney tried to impeach that individual by saying, oh, well, in your psychological evaluation, it says you were in the desert for 3 days.
Hmm.
And so I do think that it's very important for evaluators to not try to get into like a huge recitation of the background facts.
Hmm.
The evaluator needs to understand that that's going to be in the client's declaration. Like the evaluator's job is not to repeat the declaration. Their job is to do the evaluation, to administer the tests, to, dig into those different types of issues you were talking about, like a predisposal to anxiety or to attachment disorder.
Yeah, and how they were affected by it.
Right.
So not necessarily what happened, but how it impacted them.
Right. So I think it's one of those things where it's like, let the lawyer do the lawyer's job, which is helping the client write out the deck, and let the psychologist do the psychologist's job, which is actually giving an independent evaluation and not having the lawyer say, hey, we really need a PTSD diagnosis on this one. Doctor, what do you think you could do? That's not how we operate at all. And so I think
Exactly.
part of the wisdom is like, let the attorney be the attorney, let the psychologist be the psychologist.
I think that is such an important point, and I really want to bring that home because it really is important. And I see it all the time, that mental health professionals just overly focusing on the facts and telling in detail the story. And that just like opens up the opportunity for so many discrepancies and consistencies,
Mhm.
questionable, which is unnecessary. Because what I always say is, we're the expert. So I'm going to tell you how this person was impacted. I'm not going to give you all the nitty gritty of how I arrived at that, like based on everything they told me.
Mhm.
Just trust that they shared with me enough for me to come to this conclusion.
Right. And it could be something that's in general terms.
Right.
The client shared with me that they were tortured by police in Mexico,
Mm-hmm.
and the torture involved.
But you don't need to say how many men were there and what day and what color.
Exactly. That's not the mental health professional's job.
Loving this episode? I've got something to make your life even easier. Grab my free introductory guide to immigration evaluations linked in the description box. It's a game changer for ensuring your reports meet legal standards. Let me know what you think. So let's switch gears a little bit and let's talk about the collaboration between attorneys and mental health professionals.
Mhm.
So as someone who works with mental health professionals on these evaluations, what are some things that you look for in an evaluator? What are some of the qualities that you look for in a mental health professionals when referring clients for evaluations?
So, a couple of the characteristics I look for are experience in previously having done immigration related evaluations, because USCIS and the immigration course look for very specific things. So, I think it's important that we have an evaluator who's familiar with the process. The second thing I look for are language skills. I think it's very difficult for an evaluation to really be accurate if the individual has to go through a translator. So I really like to try to find a mental health evaluator who speaks the native language of the person being evaluated.
Mm-hmm.
Sometimes the client themselves have preferences. Like, I would like a female evaluator, or I would like an evaluator who's also from Brazil,
Got it.
or something like that. So we would try to meet those personal needs because we want the person to feel really comfortable. And so if they're going to feel
Mm-hmm.
comfortable with a certain profile or certain characteristics, then we try to help them find that. I would look for a mental health professional who is familiar with the cultural background of individuals, especially along the lines of like the asylum cases. There may be certain traumas that are considered more severe or less severe depending on the country or the culture where the person's from. So it's a variety of factors.
Mm-hmm. Now, let me pose a hypothetical here.
Mhm.
Say this is a T visa and there is a lot of detail about what happened,
Mhm.
and a lot of detail that's even not 100% consistent with the declaration.
Mhm.
And you ask the mental health provider, hey, could you please remove all this detail because it's going to jeopardize the case? And what we really need is the emphasis on how it affected them. And the mental health provider says, nope, I've already written my report and I am not going to change it. And if I change it, I'm going to have to acknowledge the fact that you asked me to revise it and I revised it. What would you do?
No, I would not work with that mental health evaluator again.
Mm-hmm.
I mean, I think it's really important for evaluators to realize that an immigration attorney may have met with the client for 15 hours to get their story. And how long does a mental health evaluator usually meet with the client for the evaluations?
Depends on the case, but about 2 hours maybe,
Right.
face to face.
So that just because the mental health evaluator's perception is that the client told them, let's say, less than what was in the original declaration, there may not be actual inconsistencies. It may just be a misunderstanding. And I think I appreciate evaluators who understand, hey, people who are traumatized might remember something slightly different from one day to the next, or be understanding if I say, hey, I do see that your report is inconsistent with the declaration. Let me go back to the client and give them the opportunity to clarify.
Mm-hmm.
Or even to have the evaluator say, well, let me call the client and attempt to clarify. And then somebody might realize, whether it's the attorney or the evaluator, oh, there was just a simple misunderstanding, especially when we're working across language barriers.
Right.
This person used a slang term that I didn't understand and I wrote it down wrong in my declaration, or you wrote it down wrong in your report,
Mm-hmm.
or we're missing the connotation of something. So I prefer to work with a mental health evaluator who is open to having a conversation, to going back and forth a little bit, open to understanding and acknowledging that maybe during those 2 hours they didn't learn absolutely everything about the case. And just because something may be different in my file doesn't mean the client's lying.
Mhm. Right. Well, so along those same lines, I mean, writing an effective immigration evaluation isn't just about the clinical expertise. It also has to meet legal and ethical standards. And there's a fine balance between advocacy and objectivity.
Correct.
So, what should mental health professionals avoid including in the reports, or how can they maintain that balance?
I think the most helpful report is a completely objective report. If there's something that sounds like an advocacy piece, that's not really the role of an evaluator. An evaluator should be independent. As an attorney, I'm an advocate.
Right.
So again, it goes back to the let the lawyer be the lawyer, let the mental health professional be the mental health professional. Let me do the advocacy. I'm the one standing up in court and saying, Your Honor, this person deserves X, Y, or Z. It's not the mental health evaluator. The mental health evaluator is there to say, this client expressed that he's not able to sleep at night. This person expressed that he has a decreased appetite. We administered a test where our determined that this person is suffering from anxiety. It should be very objective. It should be clinical. It should be clear that it was written by a doctor or other mental health professional. Leave the advocacy to the attorney.
I think that's a really, really good point. Is that what you would say is one of the most common mistakes that you see mental health professionals making in immigration evaluations?
Yeah, I would think so. Fortunately, I don't see that too often because I work with some extremely qualified people,
Mm-hmm.
and I have not seen that too much to be an issue, but I can imagine that it would be.
Mm-hmm.
I would say one of the larger mistakes I've seen we already talked about, which is the mental health professional trying to include too much detail about the patient's backstory. Again, going back to that example, that was the first time I'd ever seen a psychological evaluation used to impeach a client's testimony, but it was pretty startling. And I could imagine that that's going to be used more and more as the Trump administration is replacing immigration judges. I mean, right now they're firing immigration judges, but the fear is that they're going to be replacing them with harsher immigration judges who are more inclined to decline cases. So, what we have to do, both mental health professionals and attorneys, doctors, I mean, all of the care providers for the client, is provide the best record, the cleanest record, the most objective record, the most consistent record possible. So, if and when the client loses in immigration court, we have a great record for appeal.
Mm-hmm.
So part of the reason I'm always thinking about things that way is because my law partner, who happens to be my husband, is a federal appellate attorney. And so if we lose a case, then he will often be the person taking it up to the Ninth Circuit. The Ninth Circuit is not going to change dramatically depending on which president is in office because Article 3 judges are appointed for life.
Right.
So they tend to be extremely objective. So if you've got some kind of a political hack as the immigration judge who's just giving a horribly reasoned decision, you know, misstating the law, really undervaluing certain types of evidence and saying, oh, there's no evidence at all that this person suffered. And there's a really clear objective evaluation that contains really detailed information about how the tests were conducted, what the client's test results were, not just an extra recitation of the facts. That's something that the Ninth Circuit might look at when they're evaluating whether the immigration judge made a mistake.
Right. Now, you wouldn't bring an expert witness to testify in circuit courts, right?
No, you would not, but you would already have the record set. So ideally, when I'm preparing a case, I don't just sort of think, oh, it's Judge so and so. He likes me.
Right.
I can just do a few this and that. I can just do a little bit of this.
Mm-hmm.
It doesn't work that way
Yeah.
because what happens if Judge so and so is sick that day and there's another judge sitting in and that judge expects a fully documented case and you haven't provided it? Or what happens if even the nice judge who likes you doesn't think that your case has merit and denies it? So for every case,
Don't take anything for granted.
don't take anything for granted, document everything. And so that includes mental health evaluations, but it includes all kinds of things. I put crazy things into the record just to prove everything the client's saying. So I had a client, for example, saying, I had such and such of a job in my home country. So then we submit a copy of that person's professional license from their country, just like documenting every single statement that the client says that's actually documentable.
Do you think you'll be more inclined to want to have an expert at a court hearing now, whereas before you weren't, like just in case?
Yes. So under the Bush administration, which was by far the harshest administration under which I have practiced immigration law, interestingly, everybody would guess it was Trump, but it was Bush.
Really?
Yeah, I would often ask.
Well, give him a few more months, right?
I know. I would often ask the mental health evaluator and the doctor to be willing to come into court to testify if necessary. And I remember a particularly contentious case in which we did have, I think it was the medical doctor there, and it was really important testimony to the case. That case lost at the immigration court level, but it won on appeal.
Interesting.
And so I do think it's because we had such a comprehensive record, including a doctor's testimony.
Right. Yeah, that's what I'm anticipating too. I don't think you've ever had me come to court, but I wouldn't be surprised if that's the case now.
I might have to start asking you.
Well, and that's a whole issue for us, because one of the questions that I will dedicate a whole episode to testifying in court from my perspective. But one of the things that a lot of mental health professionals ask is like, well, how do we charge for it? And it's really hard because a lot of these times, first of all, we may never end up testifying, right? So we're there as a just in case,
Right.
but we still need it to clear our schedule in order to be there.
Oh, yeah.
And also, it's not the court paying us, it's the client. And, it's a lot of money.
Mhm.
So it puts us in a very difficult position, especially again, when we don't end up needing to testify.
Well, I think what would be fair would either be to charge by the hour.
Hmm.
Let's say you get to court, and if the immigration judge says, "Oh, we're not going to need to hear from you today, Dr. Shibley. I already read your report. It was very comprehensive. You may be excused." Then the client isn't being charged very much money, right?
Hmm.
Because let's say you were there for an hour and a half total, including your travel time, then that could be a reasonable expense for the client.
Hmm.
Or just having a flat fee if, like you're saying, you have to clear your total afternoon, you're not able to, fit in patients because you're expecting, "Oh gosh, I may have to be there from 8 a.m. to noon, and even if the judge excuses me at 9 a.m., it doesn't matter, I'm still not able to take any clients during those slots, and I'm losing my income." Then maybe a flat fee would be more fair to you. And I think
Right.
as long as it's explained to the patient ahead of time, and especially that's the cooperation piece of having the immigration attorney explain, "Hey, ultimately it's your decision, but I believe it would be incredibly helpful to have the doctor there to testify. This is what her fee is for appearing in court. It's your choice, but I would recommend it." And then the client can say,
It's up to them.
"Yeah, it's up to them. Like,
Hmm.
gosh, I would really love to, but I truly honestly don't have the money." Okay, that's fine. Like, nobody's asking, well, they might be, but they shouldn't be asking you to work for free.
Right. Well, that's why we need nonprofits to help subsidize the cost of the evaluations and the hearing. So it's fair for everybody, right?
Right. That's absolutely
Hmm.
the case. The most common, the reason I don't think I've ever had you testify is usually if I have a mental health professional testifying, it would be somebody who was from Survivors of Torture International,
Right.
because those are free evaluations if the person meets the criteria.
That's right. And they get paid.
Yeah, they get paid to be there, right, by the organization.
Exactly. Well, Ginger, this has been an incredibly insightful discussion. But before we wrap up, do you have any final advice for mental health professionals looking to improve their collaboration on immigration evaluations?
Sure, I would say number 1, be very open with your communication. Let's say something came out during the evaluation and you feel like, "Gosh, I'm really not gonna be able to support what you're asking me to, try to validate or verify." It would be better to call the attorney and say, "Hey, here's what happened. I think the client might be holding back. Maybe you could talk to them and we could schedule a second appointment," instead of just writing up a report that says, "Nothing's wrong with this client."
Right, which is basically just wasting the client's money.
Wasting the client's money and wasting everyone's time.
Yeah.
So I do think a collaboration is helpful. I do think it's really helpful to be open-minded. If an attorney is saying, "Hey, I know you just focused your whole report on hardship, but we're not looking at hardship for this case type. We're looking at something else." Hopefully that conversation would take place before the evaluation.
Yes.
But all of us are learning as we go along, right? We're all learning how to work with each other effectively. But it would be good to probably have some kind of an intake process where you may be asking the attorney, "Okay, what are the main things that you would like us to evaluate?" And so in a recent case I had, for example, one of the main things we needed to have evaluated was why the client didn't file earlier.
Hmm.
And it was not so much what happened, and
Right.
it was why did you wait 4 years to file your application? And so that's like a totally different question
Exactly.
than what you would normally ask. So, I mean, both attorney and therapists need to be talking about, hey, how do we best help this person together?
Yeah.
What is it exactly that you need? And I do think it's also helpful if the mental health professional is like, hey, I've never worked on this kind of case before. Could you give me some more information, attorney friend?
Hmm.
What are the legal requirements? Just so I know like what I'm looking for and how I can best be of service. So I think it's really helpful for both the attorney and the psychologist to go in with a really open mind. And I know attorneys sometimes can be kind of condescending and be like, I'm the attorney, I know everything. And maybe some mental health professionals can be that way as well. And so I would say to both attorneys and mental health professionals is put your ego to the side, try to learn from each other. And you're on the same team, both trying to, help this patient or client achieve their goals.
Right. Keep your eye on the ball.
Mhm.
And we have a referral form that we send to attorneys, especially any new attorneys that refer to us for the first
Mhm.
time. We send them the referral form for exactly that reason, because it's happened many times where, the client doesn't necessarily know what they need. They're calling and they're saying, I don't know, my attorney told me to call and make an appointment. They don't know if it's therapy. They don't know if it's an evaluation. They don't know what type of case they have. So we have to kind of ask all the right questions to determine, okay, this is a VAWA, or okay, this is a cancellation or removal. And when the attorneys can fill out these forms and send them to us or give it to the client to bring to us, so we avoid those misunderstandings. And there is a space, for like notes, like in this case specifically, focus on why they didn't file on time, right? And we get that, and that makes such a big difference.
Yeah, absolutely. I confess to being one of the people who does not always fill out the form, but it's something I need to be better at because I realize the value of it.
Right. And some people don't fill out the form, but, people that I worked with for a while might shoot me an email and tell me a little bit about that case because it's unique. But if it's not, if it's a standard, you already know how I work, you already know what to expect, then there's no need for that because there's nothing different, nothing unique about this specific case. So it's understandable.
Exactly. And I do appreciate conversations I've had with you and people on your team about, hey, this is, a different case type than what we usually handle. Here's what we're looking for. Here's what would be most helpful. We would normally look at this, but in this case type, we look at something else. So just being really developing a friendly and open relationship between the attorney and the mental health professional, I think is incredibly helpful.
Absolutely. I agree. Well, Ginger, it's been a pleasure. Thank you so much.
Likewise, you're very welcome.
Yeah, and hopefully this won't be the last because I know you're very knowledgeable about maybe, next time we can focus on something more specific, a type of case or new trends or et cetera. So hopefully this won't be the last time you are a guest.
I agree. I would love to come back.
All right. I appreciate you spending time with me today. If you enjoyed this episode, share it with a fellow mental health provider who needs to hear it. And if you haven't already, hit subscribe so you don't miss my next one. See you then.